Give the floor to the distinguished representative of Sri Lanka.
Madam Chair, I thank you and the members of the ILC for the report of the ILC and for carrying out the mandate through such difficult times. It is clear that the Commission has, as obliged by the Charter, focused on the rule of law and the promotion of the progressive development of international law and its codification. In this process, we must appreciate that the Commission has taken and given primacy of place to the rule of law as a principle of governance and human rights has been fundamental to the rule of law, as reflected in the preamble and Article 13 of the UN Charter. It is also clear that the Commission has been conscious of the aspects of peace and security, development and human rights, and their connection with the rule of law, and has also been cognizant of the 2030 Agenda for Sustainable Development. Madam Chair, as we are aware, the recent session of the ILC followed the postponement of its session due to the COVID-19 pandemic, and we see it has hitherto continued to address the issues of the protection of the rule of law, the protection of the atmosphere, the provisional application of treaties, the immunity of state officials for foreign criminal jurisdiction, sea level rise in relation to international law, the succession of states in respect of state responsibility, and the general principles of law. It is encouraging to note that the Commission had adopted a hybrid format to enable its members to participate either in person or online with remote simultaneous interpretation in all the official languages of the UN. No doubt, the adaptation to the new normal of working in a hybrid format contribute to the successful conclusion of the sessions. Having had due regard to COVID-19 mitigation measures, it is commendable that notwithstanding the several hardships due to COVID-19, the Commission had adopted extraordinary measures to ensure the smooth conduct of its deliberations. It had many challenges, such as the reduced hours of operation, which hampered the decision-making and negotiating process as members were in different parts of the world. Due to these conditions, interpreters, for example, were available only for shorter periods, limiting the Commission's meetings. There was a limitation to informal consultations, as we know. We must also commend the members who had to work in different time zones, online at unsociable hours of the day. The ILC has admirably risen to the environmental challenges of the times. I am pleased to observe, Madam Chair, that the Commission had given much importance in its functions as to the progressive development of international law, as I said before, and its codification, and had particular relevance to state practice and the decisions of national and international courts in dealing with questions of international law. It had called for the availability of evidence of state practice. It had taken into account the reports of special rapporteurs, which sets out the presentations of precedents, treaties, judicial decisions and doctrines. It would appear that the Commission had also stressed on the importance of the timely preparation of reports and their submissions before the start of the relevant part of the session, which perhaps was a commendable development. It has also taken the salutary step of following the measures introduced at the 65th session to streamline the processing of its summary records. Madam Chair, we note that the topic protection of the atmosphere resulted in a set of draft guidelines with certain recommendations made to the General Assembly, so as to enable the attention of states, international organizations, and all who may be called upon to deal with the subject. The topic of the provisional application of treaties also resulted in draft guidelines. With regard to the provisional application of treaties, it was heartening to note that the Commission had taken into consideration the report of the Special Rapporteur regarding the immunity of state officials from foreign criminal jurisdictions, which had examined the relationship between the immunity of state officials from foreign jurisdictions and tribunals. The topic of succession of states in state responsibility was timely, I say, as it addressed questions relating to the impact of state responsibility in relation to different forms of reparation, the obligation of cessation, and guarantees of non-repetition. The Commission had also invited states to provide it with practices relevant to the section of states in respect of state responsibility in connection with treaties, domestic law, including legislation, implementing multilateral or bilateral agreements, and the decisions of domestic, regional, and sub-regional courts. Madam Chair, it must be considered most appropriate that the topic of sea level rise in relation to international law has been given a special place by the reconstitution of the study group, which is required to consider issues relating to the law of the sea. Another progressive step we see is that the Commission had adopted is the re-establishment of the planning group to consider its programs, procedures, and working methods, which in turn is expected to re-establish the working group on the long-term program. It may be pertinent to make the observation that the Commission's focus on the sources of international law has been well received by states and the international legal community. It is noteworthy of comment that the Commission has completed studies with the objective of clarifying treaties and customary law. Madam Chair, the value of the work of the ILC is immeasurable, today more than ever before. The significance of a strengthened justice system and a strengthened rule of law are apparent as the need of the times is a more sustainable and equitable future for all mankind and accommodation of compassion, understanding between nations, whilst ensuring legal protection which is effective and efficient in engaging with current global challenges. I therefore call upon Member States to provide the necessary support and impetus to the ILC, without which whatever it does would be mitigated. I invite the members of this August Assembly to have a greater appreciation of the fact that international law, which is also known as public international law, is a body of legal rules between sovereign states and other entities that are legally recognized as international actors, and what the system perhaps suffers from is the absence of a central enforcement mechanism which we would eventually achieve. I leave you with the important question whether it will be just rhetoric or whether the international community will be able to agree on a system to which member states can be compelled to submit. I thank you, Madam Chair.
I thank the distinguished Parliament representative of Sri Lanka. I now